You know, every single day, millions of us deposit checks. It feels totally normal, right? A simple, routine transaction. But for the bank on the other end, the one we call the collecting banker, there's this whole hidden world of legal risk. What happens when the check they're collecting isn't as straightforward as it looks?
So let's paint a picture. Imagine a check gets stolen. The thief forges the signature and then, bold as anything, walks into a bank and deposits it into a brand new account. The bank collects the cash, credits the account, and then the real owner shows up. So who's on the hook for that loss? The person who wrote the check? The bank? The person it was meant for? This is the exact problem we're going to dive into.
Now, the fancy legal word for this whole mess is conversion, but all it really means is handling someone else's property as if it's your own. So when a bank collects a check for someone who doesn't legally own it, like our thief, they've technically converted that check. And here's the kicker. That means the true owner can actually sue the bank for the full amount. You can see why this is a massive deal for them.
All right, so here's our roadmap for today. We're going to start with the banker's hidden risks, then we'll look at the legal shield they have to protect themselves. After that, we'll get into the juicy stuff, real cases where that shield completely fell apart. And finally, we'll put it all together into a checklist for how banks can stay protected.
Okay, first things first. We have to understand the bank's role here. When a collecting bank takes your check, it's doing more than just moving money around. It's actually acting as your agent. And that job comes with some very specific responsibilities.
So the bank has three big duties to you, its customer. It has to act in your best interest, it's got to present that check for payment pretty quickly, and if it bounces, they have to let you know right away. Simple enough, right? But the real danger for the bank isn't just failing you, it's the risk of helping out a customer who has, let's say, a defective title to a check. And that brings us right back to that big, scary problem of conversion.
So if a bank can be sued for every stolen check that passes through its system, how could they possibly function? Well, the law gives them a way out. It's a specific piece of legislation that acts like a legal shield, especially for what we call cross-checks. This amazing tool is Section 131 of the Negotiable Instruments Act.
And this right here, this is the magic formula. The law basically says that as long as a banker collects a cross-check in good faith and, this is the most important part, without negligence, they're safe. They're protected from being sued. Even if it turns out their customer wasn't the true owner, the bank is in the clear. Those two little conditions, good faith and no negligence, are everything.
You can really see the two different paths here, can't you? The line between being protected and being liable is razor thin, and it all boils down to one thing: diligence. Acting in good faith is pretty much a given. The real fight, where banks either win or lose their shield, is proving they acted without negligence.
So, what does negligence actually look like when we're talking about banking? Well, the best way to get it is to look at real court cases where banks got it spectacularly wrong and lost that legal shield. Trust me, these stories are, well, they're pretty eye-opening. Before we jump in, what does negligence even mean here? The courts have a great definition. It's the failure to act like an ordinary prudent man or a reasonable banker would in the same situation. It's not about being a superhero, it's just about being reasonably careful. It's the common sense test. Let's kick things off with a classic case, Ladbrokes versus Todd. This is a perfect example of negligence happening at the very first point of contact, opening a new account for a complete stranger.
So the story is simple, but the outcome was a big deal. A thief just strolls in, opens an account with zero proper references, and deposits a stolen check. The court came back with a crystal-clear ruling. Opening an account for a stranger without asking any real questions is basically the textbook definition of negligence. The bank lost its protection, and they had to foot the bill. Ouch!
Okay, so the lesson seems obvious. Get a reference. But what if the banker does get one? Is that enough? Well, this next case, St. John's versus Barclays, shows us that just ticking a box isn't going to cut it.
Honestly, this case is almost funny if it weren't so serious. A guy opens an account with a fake name, but when they ask for a reference, he cleverly gives his real name. The bank employee just writes it down and never bothers to check it. The court decided that not following up on the reference was negligent, and, you guessed it, the bank's shield was gone.
You know, negligence isn't just about opening new accounts. It's also about paying attention to the transactions themselves. This next case really drives that point home.
So, in this situation, a company's managing director was routinely taking checks made out to his company and dumping them straight into his own personal account. This should have set off every alarm bell in the building. A reasonably prudent banker would have immediately asked, hey,
Why is company money going into a private account? Because they failed to ask that one simple question, the bank was found negligent.
Okay, so we've seen how badly things can go wrong. So how does a bank get it right? How do they consistently prove they're acting without negligence? Well, it all comes down to having a systematic process of due diligence.
The absolute first line of defense, before anything else, is the physical check itself. A good banker has to be a bit of a detective. Is the date okay? Not too old, not for the future? Do the numbers and the words match up? Does the signature look legit? Are there any weird alterations? These basic checks are the very first wall against fraud.
And this right here brings us to the complete blueprint for earning that Section 1331 protection. Number 1, scrutinize the check. Number 2, know your customer. Don't make that same mistake from the Ladbro case. 3, question strange transactions, avoiding the huge red flag from the Underwood case. And 4, always act fast and follow procedure. This isn't just a random list. It's the very definition of an ordinary prudent banker.
And all this leaves us with a final thought to chew on. We've been talking about paper checks, but the core idea here, the duty to act with reasonable care to stop fraud, is totally timeless. In today's world of instant transfers and sophisticated digital scams, isn't this century-old standard of the ordinary prudent person not just relevant but maybe more critical than it has ever been?